What are the WARN Act rules for mass layoffs? Imagine losing your job unexpectedly and not knowing if your employer followed the law to give you enough notice. That's where the Worker Adjustment and Retraining Notification Act comes in. This law sets clear rules for employers when they plan to lay off a large number of workers at once. It's all about giving employees time to prepare, look for new jobs, or get retraining. A mass layoff under this law happens when many employees lose their jobs at one location in a short period. The law says a mass layoff is when at least 500 employees are laid off in 30 days, no matter how big the company is. Or, if at least 50 employees are laid off in 30 days, and those employees make up at least a third of the workforce at that site. Part-time workers are not counted for these numbers, but if they are affected, they might still need notice. The law also looks at smaller layoffs over a 90-day period. If these smaller layoffs add up to meet the threshold for a mass layoff, the employer must give notice unless each layoff was separate and not connected. Employers covered by the WARN Act must send written notices to affected workers, employee representatives, and certain government agencies at least 60 days before the layoffs happen. The notice can be sent by mail, hand delivery, or included in a paycheck. If an employer does not give proper notice, affected employees can claim back pay and benefits for up to 60 days. They can also file a lawsuit to get these payments. The law applies to private companies with at least 100 full-time employees or a total of 4,000 hours worked by full-time and part-time employees each week. The law covers layoffs at a single site, like a factory or office. Employers need to carefully track their workforce numbers and the timing of layoffs to see if the WARN Act applies. If they don't follow the rules, they can face big penalties, including paying back wages and benefits, and possibly fines. These rules are part of the larger process of managing employment contracts and employee terminations. Employers should include WARN Act compliance in their planning for layoffs or reductions in force. This way, they meet their legal duties and protect employee rights during tough times.